Hi, my name is Lizzie Chan, and I'm a member of the CPR Institute's Young Leaders in Alternative Dispute Resolution Steering Committee. I am delighted to host today's episode of our CPR Y-ADR Corporate Counsel interview series. Y-ADR seeks to educate the next generation of young practitioners on the full spectrum of dispute prevention and resolution techniques, and to provide an insider's view to CPR's community of in-house counsel, law firm counsel, and other experts in the field who are using dispute prevention and resolution techniques to manage conflict and to enable purpose. As part of this goal and this interview series, I will be asking corporate counsel about best practices in ADR and to share their advice for young practitioners. Today, I am very excited to welcome Xing, who is legal counsel at General Motors in Shanghai. Kelly, we're very excited to have you with us today.
Hi, Lizzie.
My first question to you is, please tell us a little bit about your education and career background and what your role is now at General Motors.
Right. Hi, this is Kelly, and I'm currently working at the General Motors. My main job responsibilities are to negotiate various commercial transactions between General Motors and its joint ventures, partners, and suppliers in China. I've been with General Motors for about 6 years. And before joining General Motors, I was a general counsel at a French consumer finance company. After 5 years of working experience in a law firm and an external attorney, I was born and educated in Shanghai.
Thank you so much. You have such an interesting background and in-house counsel experience at a number of different companies. Now, just focusing in particular on your role at GM, what things do you consider when you're drafting a dispute resolution clause?
Right. So in the agreements between General Motors and its joint ventures, for example, the dispute resolution clause is one of the key clauses in the agreement. And because of the relationship between General Motors and the joint ventures, we try to leverage the management interactions between both parties and design a mechanism that is suitable for both parties to execute under that clause. So I would say the first level is that we will use the management team from both parties in terms there's any issues arising from the agreement. And if that does not help, then we will escalate to the senior leadership. So that's the level 2 dispute resolution. And the third one, if all these efforts fail, and then both parties can submit the dispute to the arbitration center for the dispute resolution. So this is basically the dispute resolution mechanism that we have in place in the agreements between General Motors and its joint ventures in China.
And if you are using arbitration in your dispute resolution clause, what is your preferred law and preferred seat, and why?
Well, so right now we choose the law of Singapore, and we use the arbitration forum to be the Singapore Arbitration Center. The reason for that is because when GM negotiated its commercial transactions with Chinese joint ventures, I think it is in the best of each parties to have a fair and unbiased governing law and the arbitration center in place in the agreement. So because one party is from the United States and the other is from China, so they finally decided that they will choose Singapore as the, let's say, a neutral place for the governing law and the arbitration place.
And, why is it that you've chosen Singapore law as opposed to, say, English law or Hong Kong law?
Right. So most of these agreements were negotiated actually 10, 20 years ago. So back at that time, for the Chinese joint ventures, they want to have something similar to China and not entirely English. So they do not know that well about English law. So that's the reason why they don't want to have the English law as the governing law. Same with the arbitration center, because the Singapore arbitration center seems to be acceptable to both US companies and the Chinese companies. That's why they decided that they will use this as the arbitration center.
As you know, there is now an interim relief arrangement between Hong Kong and China, where it is possible for parties to seek interim relief in mainland China for Hong Kong seated arbitration. Does this development, or would this development affect the negotiation of your arbitration clauses going forward?
Right. Thank you, Lizzie, for bringing that up. Yes. I think that would be a very good initiative going forward, to use the Hong Kong laws or the Hong Kong Arbitration Center as our dispute resolution mechanism. I think both parties will be happy to see that. But the thing is that we have agreements negotiated many years ago using the Singapore law. So I'm not sure whether it's in the best interest of both parties to reopen that negotiation from this point to use the Hong Kong laws. But I think definitely that is something that we can consider in future.
And is there anything particular about the Chinese cultural context that you think has a relevant impact on dispute resolution?
Yes, in my view, I think the mainstream dispute resolution mechanism in China is definitely not the court litigation or the arbitration, because in my view, Chinese society is really a relationship society, and we really want to discuss and negotiate with the other party if there's any issue coming out of the execution of the agreement. And we want to discuss with them in the first place instead of resort to the court from the very beginning. So one thing to mention is that in General Motors China, we are headquartered of General Motors in China, and we don't have much cases going on. We only have 1 or 2 pending cases, and that's very few, right? And for the joint ventures of General Motors in China, actually they're a bigger company. They have like 28,000 employees, and they have full-blown sales, after sales, and engineering functions inside that company. And even for that kind of company, their cases is not huge. They only have like 10 or 20 cases per year. I don't have the exact number, but my impression is that the cases number are not huge. And I'm not saying that they don't have any disputes with the suppliers or vendors. I do think that they did a great job by discussing with their counterparties in the first place when they sense that there's any issue arising from the execution of the agreements. And they try to approach to the counterparties, and they discuss together about how to resolve the issues arising from the performance of agreement, and how to find a win-win solution out of that dispute. So that is the most valid concern from both parties, instead of going to the dispute resolution through court or through the arbitration, which may take a very long time, and maybe nobody will win out of that situation. So I would say that for Chinese people, we're trying to discuss and negotiate and to prevent the dispute from escalation. That is the first thing that we want to do if we sense there is any dispute going on.
Speaking of win-win solutions, how has the COVID-19 pandemic affected the way your company resolves disputes risks?
Right. So I think everybody knows that the pandemic has a huge impact globally. It affects not only the Chinese companies, but also the US companies and the companies of other places and regions. And under that special circumstances, I do think that there's a lot of issues very special to the pandemic. For example, if the pandemic orders a shutdown of one city, then the manufacturer, they cannot just manufacture the products and sell it out of that region because that region is in shutdown. So that is one special cases related to the pandemic. And the other impact may be the company decided to reserve the cash flow because of the pandemic, and it does not want to continue the services that its suppliers renders and want to suspend that services. So under all these circumstances, I would say that we have made great efforts to identify the issues, and we try to discuss with our counterparties in the first place to raise that issues in a very transparent way. And then we discuss jointly what will be a good solution, because the impact is really on both sides. It's not just on one side. Then it will be in the best interest of both parties to find a good solution out of this pandemic, instead of resorting to the court or the arbitration for dispute resolution. So this is one good approach that I would recommend here. And the other thing is that we are not talking out of the legal context, because we have a legal contract with all these counterparties, and we have the force majeure clause in nearly all of these contracts. And we have done is that we have engaged an external counsel to help us vet the legality of the force majeure and how the pandemic falls under the force majeure and what is the legal impact associated with the pandemic. And then we get a legal analysis in a sufficient way, and we get it prepared just in case any third party will, claim that we are not performing the contract. Then that's the point where we can raise the force majeure as our possible defense.
So you've had experience working both as external counsel and in-house counsel in a number of companies. What do you think that external counsel should understand about their client companies and their counsel?
Right. So I appreciate all the efforts from the external counsels, the law firms, because they have done a really good job in providing a legal analysis, and they have done extensive legal research in terms of the laws and regulations and court decisions, etc. But I would say one other aspect is that we would need to better understand the business environment that the client is in and what is their real business concern, because behind each of the legal questions, there must have some the business interest to pursue with. So for the external counsel, probably they need to figure out what is the background of the question and what is the business environment that the client is in and what is their real business concern before they provide any legal advices. And after providing the legal advices, I would recommend the outside counsel to follow up whether those legal advices are accepted and followed through by the client. This is very important because for some client, maybe the legal practice is something on the paper, and they cannot just purely exercise based on that legal advice because of all kinds of real constraints or business constraints. But I would recommend that outside counsel, they need to think more about the client's real concern and work with the client together to provide a solution-oriented legal advice.
That's a really good point for external counsel to better understand the client company. And I suppose one of the challenges that young external counsel may face is that communications with the client are often channeled through the senior associate or the partner. But perhaps, one advice is for young practitioners not to be afraid of reaching out to in-house counsel, inviting them out for a coffee and really showing an effort to better understand the company.
Right.
And I know you moved in-house into General Motors. So what did you do to better understand the company and the various non-legal functions in the company?
Right. So I did not have any automobile experience or manufacturing experience before joining General Motors. I was more on a finance company. I have a banking background, but I don't have a background in a manufacturing company. So after I joined the General Motors, nearly everything is new to me. And I try to join the meetings as much as I can, whether it is a legal meetings or business meetings, whether it's a purchasing discussion or a business discussion, doesn't matter. I will join as much as I can. And for those terminologies that I am not aware of, I will talk with our colleagues to understand what is the meaning of that terminology and what is the issue at discussion. So this will help me quickly merge into this company and understand its culture and the business and the process. And another thing I did is that I reach out to our global attorneys based in the United States. So they're really experienced attorneys and focusing on different areas such as the product liability and intellectual property. So I will talk to these attorneys and get their inputs respectively on the transactions to understand their view and try to discuss with our business stakeholders internally. And then I can better understand what is our company's position in terms of each of the issue for the agreement. And I basically did this every day. So that will help me, quickly learn about how to be an in-house counsel in General Motors.
I really admire your proactive attitude and the serious attempt you made to get to know the company and its culture and its various functions better. And my final question for you is, what is your advice for young practitioners looking for a career in-house?
Well, I think to be an in-house counsel is never easy. It requires not only the legal expertise, but also the business acumen. So for the external attorneys who wishes to go in-house, I would recommend that you think carefully, because that is not a pure legal environment that you will be in. And once you decided, once you have made that decision to join in-house, I would recommend that you try to reach out and try to discuss with various functions inside the company, and not just stay in the legal, but also go outside to see your business clients, to talk to them and to formulate a position that is in the best interest of the company is not easy, but it's also the challenging and fun part of being an in-house counsel.
Thank you much. Thank you so much, Kelly, for your time today and the wonderful insights that you've shared with us. We're very grateful for your time. And we also thank our audience for tuning in.
Thank you, Lizzie.